shining a light where the shadows creep, for the lost, the stolen, the ones who will weep. She won't turn away, she won't back down, even when the loony clowns come round. Threats don't shake her, lies don't win. She stands for justice, right till the end. Want the truth, want the best, wanna be safe as you chat. Find kid true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Chase fame, some chase views, but she fights for those with nothing to lose. For the kids who vanish without a trace, she won't stop till she cracks the case. They try to silence, they try to scare, but truth don't break and she's still there, calling out monsters, showing their game. Justice comes when you speak their name. Want the truth, want the best, wanna be safe as you chat. Find kid true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Need a voice, kids stand strong. She makes the choice for victims gone, for those in need. She's fighting hard, she won't concede. Want the truth, want the best, wanna be safe as you chat. Find kid true crime, it's worth your time. She's got your back, she's on the
Good morning. Hey, Turtle Dove, good evening. So you must be in another country, huh? Okay, here we go. I want to say hi to everybody in the bushes. Hey, Patty Sturgis. How's it going, girl? Okay, I want to show you guys this real quick. These are the two people we're going to be talking about here. To the left is Oscar Smith. Okay, he's in Tennessee. To the right is Matthew Johnson of Texas. We're going to talk about them. Oh, West Australia, another Aussie. Hi, Triple. All right. So we're going to watch some videos of these guys. Boy, they're sad. But we might not go through the pills, but we might go through their appeals. Okay? So let's look at their DOC first, booking. Let's see. We're going to go to Matthew first. We'll go to Matthew. No, that's not him. Oh, it's your first live here? Welcome. Misty, how you doing, girl? Let's see here. Where is... There he is. All right. Let's see how the screen looks here. Make it bigger for you guys. There we go. Good morning, roller coaster. How are you? Okay, I'm out of StreamYard now, so I can't see your comments. Okay, this is Matthew Johnson. Date received 12/5/2013. He was 38. Date of offense was May 20th, 2012. Let's see, in the county of Dallas. He's a native of Texas. All right. Robbery and evading arrest. And the summary of incident. The subject walked into a gas station with a plastic bottle filled with bleach and continued behind the sales counter where the victim was working. Sorry, guys. He took cigarettes and lighters from behind the counter and cash from the register. The subject poured the bleach on the victim and set her on fire before walking out of the station. The victim died later at the hospital as a result of her injuries. Oh my gosh. Let me tell you something about Texas. Texas don't play. California don't play. We know Florida don't play. When you do cases like this, when you like people on fire, anything you do with children and other ugly offenses, you're done. You're done. You know this one? I've never heard of this one. Wait till we get to Oscar. Oh my. Oh my God. And I think the only reason why is because listening to the 911 call with one of the kids asking for help. Did I say hi to roller coaster? Yeah, I did. Okay, we're good. I haven't heard of it. He's never apologized to the family. Let's get to what the family says here. Okay, let's look at this one first. Okay, it says here, man who set Garland clerk on fire sentenced to death. And then I just told you what he did. Okay, they say he was high too. Nancy was 76 years old. The jury deliberated for 2 days. All right, let's listen to what her kids say. I think that's the most important here. The victims.
Hope the screams of my mother tear at your soul for eternity.
A family's grief on full display today in Dallas, lashing out at the man who killed their loved one by setting her on fire. It will not bring their grandmother back, but tonight one family says they will sleep a little better, knowing that the man who killed her will never be able to hurt her again.
Yeah, this afternoon, a jury sentenced Matthew Johnson to death. The Garland man admitted to robbing, then lighting 76-year-old Nancy Harris on fire in May of last year. She died days later. NBC5's Amanda Guerra is live at the courthouse. Amanda, how long did it take the jury to reach this decision today?
Well, Meredith, over the course of 2 days.
Is that all they're going to give me? I guess so. That's too bad we didn't get to listen to what I call them kids. They're not kids, though, people. Hold on a minute. There's something going on with this screen here. Whatever. Okay. Oh, I didn't say. These executions are for April of this year. Let's see, what else do we got on him? Okay. Let's just go here. I want to tell people, and I keep explaining it to people. Yes, it was like a gas station type thing, or maybe a little mini grocery store. I don't know. Right? Now, let me tell you something. There's people that complain that they're against the DP. Sometimes I don't know how I feel about it, but I feel if you do something to children, definitely out. And there's certain other cases that don't have to do with children that deserve it, okay? But what's most important is what the family wants. It's what the family wants, not what we want, because we're not living their nightmare. We get to close our laptops and shut off our phones every night, right? But they're living it every day, every day. So it really don't matter, honestly, what we think. It's what they choose. Okay, let's look at his appeal. Yeah, because people go, you guys, I really get judged. But that comes with being a creator, right? Because I give my opinion, I do what I want, I reach out to the inmates, because if I have a question, I'm going to ask, and I can say whatever I want to say. And you know what? It's nobody's damn business. Just saying. All right. Okay, this is the Criminal Appeals of Texas. Texas don't play. We all know that. Okay, 2019, the jury convicted him. Nancy was 76 years old. Let's see here. Factual background. We want to get to the background. Okay, it was a convenience store in Garland, Texas. May 12, 2012. She opened the store at 7. Oh, there was videotape, surveillance. Oh, the appellate court got to watch it. Or no, the appellate entering the store a few minutes later, carrying a cigarette lighter and a bottle containing determined lighter fluid. Okay, I was confused. One said bleach. Lighter fluid? Holy crap. Wow. He walked around the sales counter into the employees area where Harris was standing. He poured the fluid over her head, demanded money, and stood immediately behind her. She attempted to open the cash register. While she did, unlawfully, then they're intentionally, see, those are keywords, death of Nancy Harris by setting her on fire. See, look at big words here. The appellate courts did this, people. They wrote the big words here, or in capitals. Oh, hold on. Set her on fire and did use an Exhibit A deadly weapon to fire with an accelerant, and was then and there, of course, of committing and attempting to commit an offense of robbery. So you already know here that the appellate court's like, nah, something gruesome like that, they get to look at it, we don't. He struggled with the register. He took 2 cigarette lighters from the display on the sales counter, 2 packages of cigarettes. Oh, Jesus. He also attempted to remove her ring. When it did not come off, he flicked his fingers, used the moisture to lubricate. Oh, God, he's gross. Ick. And then worked the ring off. When Harris opened the register, appellate moved to the front of her, put the cash tray on the counter, took out all the cash and coins. Second later, outside of the camera range, let's see, something on the employee side of the register burst into flames. Oh, can you guys imagine watching that? You know what this reminded me of recently? Let me come to chat. This reminds me recently. Oh, here, let's make this bigger. I'm sorry. This reminds me of that lady that got started on fire in the subway. Did anybody see that video? It's too graphic. I cannot put it on any of my social medias because they'll take it down. She did everything he asked. And he still did it. And you know what? This monster has never apologized to the family. I mean, he doesn't, what did they say? We'll see it. We'll see it here in a minute. Okay, it shows her burst into flames. The videotape next frame shows Harris on fire from her shoulders upwards, running from behind, oh, Jesus, running from behind the sales counter to a nearby sink. Meanwhile, appellate calmly walked out of the store. On his way, he stopped at his sleeve rack near the front door, selected some candy and put it in his pockets. Oh, wow. I don't know. I have no idea, you guys. All right. Harris leaned over the sink, attempting to extinguish the flames. When that attempt failed, Harris removed her burning shirt. Oh my God, you guys. And dropped it on the floor, but her, oh my God, brassiere remained on fire. Harris leaned over the sink again. Flames from the still burning shirt ignited her pants. Oh my God. She was unable to extinguish, I can't even tell, the flames. Still on fire, she made her way out of the store and began screaming. Police officer Billy Coffey testified that him and another officer, Anthony Simon, near the whip-in in the time of the fence. When they saw the flames and movement inside the store, they rushed to investigate. Okay, the weapons. Okay, this is a footnote here. Testified that the cash register would have contained more than $80. $80. Okay, they said here in the parking lot, just as Harris, who was on fire, stepped outside the store. Coffey put out the flames by spraying Harris with the fire extinguisher. Coffey testified that Harris told officer that a man had robbed her and poured something on her. She describes the perpetrator to Simon as a heavy-set black male who was wearing blue jeans and a t-shirt. Okay, and then the firefighters and the paramedics testified he treated Harris at the scene. After the officers flagged down the ambulance, he first observed first, second, and third degree burns on her face, shoulders, abdomen, upper arms, and legs. She was in a lot of pain, very worried, and repeating, "Help me, help me, help me, help me, help me, please." Jesus. She was unable to give her name and medical history. She remained conscious and was able to speak during the trip to the hospital, although her airway began to close due to swelling. Oh my God. You know what, guys? This has to be just... Can you imagine being conscious through all this? And this is what I hope. I don't know what your beliefs are, higher power, God, whatever it may be, minus higher power, that she don't feel the pain, that people don't feel the pain. You know what I mean? Let's see. Because of her rapidly closing airway, emergency room staff quickly intubated her and placed her on a ventilator. And then she again told the officer what happened before she was intubated. Okay, what does this footnote say here? Okay, it shows what Matthew looked like. Where did they find him? Let's see. Oh my God. He was located about a half a block away from the house across the alley from the whip-in. Let's see, what else did he do? He was not a smoker. Oh, okay. Okay. I see. Okay, so the guy, his driveway in the house, he didn't smoke, and he seen this stuff in his garbage can. Okay. 2 houses away, Medley saw Matthew. He testified about that. Let's see. So he kept fighting. So it's the people in the neighborhood that pretty much. Oh my God, it's 83 pages, people. Okay. We're not going to read 83 pages. Are you kidding me? All right. We're going to go to another quick article here, and then we're going to go on to Oscar.
Investigators who actually saw this crime firsthand.
Hendersonville's current police chief was working for Metro at the time and was at the scene. News 2's Kenley Hargett is here with his side of the story. Kenley?
Yes, he says in his 40 years in law enforcement, this was one of the most gruesome scenes that he has ever seen. And it happened right here on Luty Street at a house right down the road. And he says, tonight we'll finally give this family.
Oh, gosh. Okay, that's not him. Hold on. Let me find him. Sorry, guys. It's the wrong one. But it's about Oscar. So there's that. Okay, I'm looking for the... I don't know where it went. Okay, we're going to go to Oscar. That's what we're going to do. All right. Let's see how this looks. There we go. All right. This is Oscar Smith. Let's see. What was he admitted here? Doesn't say. His sentence began in 1990. So he's what? How old is he, people? When was his birthday? 1950. So what is he, 75? I can't count. So he got charged with 3 counts of first-degree murder in 1989. So let's watch a couple news articles. And I want to tell you people, he was sentenced in 2022, but the governor halted it. And this is in Tennessee, and this is the first execution that's being, what did they say? What did I read? First execution in 5 years, I think it said. All right, I got some videos pulled up of this guy.
Good evening, everyone. It was supposed to be the first execution in Tennessee since the start of the pandemic. But with only 1 hour to spare, Governor Bill Lee earlier today granted a temporary reprieve to Oscar Franklin Smith. News Channel 5's Araceli Crescencio was at Riverbend Maximum Security Institution as this all went down. She is at the 5 alert desk tonight. And Araceli, with this reprieve, it means that the state likely is going to have to wait a bit to put this back on the calendar, right?
Rory, that's right. Documents I obtained show Governor Lee's reprieve lasts until June 1st. After a delayed execution, that means they must wait at least 7 days until after that reprieve ends, which means it could be until the middle of June until Smith is executed. His attorney says hopefully that buys them time to prove his innocence. Oscar Franklin Smith has been on death row for more than 30 years, charged with murdering his estranged wife and her 2 children.
Okay, this is what I want to say also, people. Oh, God, what was I going to say? Do you know all those people that try to save these people that are against the death penalty? I couldn't find anything that any of these people have talked about well, you know what? Maybe Oscar, but definitely not Matthew.
Children, Chad and Jason Burnett. After his defense team had exhausted all legal options, all signs pointed to his execution. But moments before the sentence was to be carried out, Governor Bill Lee announced a temporary reprieve due to oversight in preparation for his lethal injection.
I'm glad they disclosed that there was something wrong, but to have something interrupted in this way is continuing to highlights the torturous aspects of this whole process.
Oh my
It was
God.
a shock for him and his attorney, Amy Harwell, who was with him when he received the news.
Mr. Smith's body visibly just sort of slumped with relief. He and his spiritual advisor gave thanks to God.
She's now asking for a full independent investigation to determine what went wrong.
We have already sent a demand to the Department of Corrections that they preserve all of the drugs, all of the packaging, all of the inserts, all of the tubing, anything that was used or was going to be used in tonight's execution.
She says this speaks to a bigger problem.
Okay. Here they're talking about how torturous this is, right? However, they did not inject him with anything. He wasn't hooked up to anything yet. It was an hour prior. Just saying. Don't come for me.
Problem regarding the state's current 3-drug lethal injection cocktail.
The first drug of the cocktail, the midazolam, actually does not prevent pain. It does not actually provide a level of surgical anesthesia. And so we were already deeply troubled by this process.
Harwell says her hope is that no executions resume until an investigation is complete and the state can assure this won't happen ever again. The state Supreme Court has denied a request to re-examine DNA evidence that couldn't be tested during Smith's trial. Prior to the reprieve being granted, the U.S. Supreme Court also denied a request.
God. DNA people. Let me tell you something. We're going to listen to the 911 call in a minute. Hold on. We're going to listen to the next thing here. All right. Now, mind you, these are old, like from 2022.
Convicted murderer is spending his last night in prison, and that's because Oscar Smith is scheduled to die by lethal injection tomorrow.
Well, on October 1st, 1989, Smith killed his estranged wife and his 2 stepsons in their Nashville home off Nolensville Pike. News 2's Kenley Hargett met the man who discovered the bodies 32 years ago when he was just a boy, Kenley.
Yes, Alex and Erica, Robert Benson was just 13 years old when he walked across the street and made the discovery that would change his life forever.
I can't say exactly how it changed my life, but I've never forgotten that day. And, and now that, this execution has gotten closer, it's really brought out a lot of emotions with me. And
there are emotions of Robert Benson's childhood that haven't changed in 32 years, just more pronounced now. Benson and his family lived across the street from Judith Smith and her 2 sons, Jason and Chad Burnett. He rode the school bus with the teenagers and knew them pretty well.
Young cousin had come across the street. He stayed with him after school every day or a couple of days a week. And he had come by and asked if I had seen him, that they wouldn't open their front door.
Benson's dad told him to go with the cousin and check on the family. The front door was locked, but he discovered the back door was open.
Stuck my head in and just hollered for Chad and Jason and a couple times, and no one answered. And so I proceeded to walk through the back part of the house.
He soon found both of their bodies lying in pools of blood. He says he ran right out of the house and told his dad what he saw. Not long after, police arrived, then news crews. Eventually, everyone left, but for Benson, the memory of what he witnessed never did.
After the murders, we lived there all through high school, and then when I graduated high school, we moved.
The images of Chad and Jason lying on the ground dead still pop up in his mind from time to time. He now hopes their family will gain some closure with Smith's death.
If anybody sees this, that, your family, Jason, Chad, and Judith, they've never been forgotten. And my family, we pray for y'all a lot and have for the past 32 years. And so I just hope this brings some type of closure for you and your family. And I hope it brings closure for everybody involved.
Sad.
At Mint Mobile, we're
Okay, let's see. What's this one? Hold on.
always looking for innovative ways to save you money, so you can keep paying $15 a month for
Is that
premium
right?
wireless.
Is that right, dude?
That's why
Tonight, the oldest man on Tennessee's death row is scheduled for execution.
Yeah, that's right. Oscar Smith was found guilty and received the death sentence in connection to the 1989 triple murder of his estranged wife and her 2 teenage sons.
Tonight, reporter Kenley Hargett speaks to the investigator who saw the crime scene firsthand.
It was one of the worst, I think, crime scenes that I'd seen.
32 years ago, then Nashville Police Captain Mickey Miller walked into a home and saw a horrific scene. 2 teen boys and their mother murdered in their house.
We had one young man, 16-year-old, Chad, was in the kitchen. He had been shot to death. And then in the bedroom, the front bedroom, Judy and Jason was on the floor. Judy was in bed, and she had been shot and stabbed, and Jason had been stabbed.
Many years have passed, and Miller has since moved on to serve Hendersonville as their police chief. But even after all this time, he says Oscar Smith still stands out as one of the worst people he has helped to put away. Investigators later identified the voice on the line as 13-year-old Jason, making the chilling call for help.
You know, probably one of the saddest recordings that you'll ever hear is when Chad was trying to call the police, and we didn't know. It was very muffled at the time. But Oscar had jerked the phone out of the wall.
Miller says it took a local radio station's help to enhance that audio to even make out Chad's voice on the 911 call. A cry for help made just moments before Smith took his life. As Smith faces lethal injection tonight, Miller believes his death is long overdue.
I think it's been much too long. I think it takes way too long to carry out justice, and if anybody deserves that sentence, it certainly would be him.
There are a few punishments as controversial as the death penalty. That's why there are several vigils going on tonight as Smith is scheduled to be put to death. One Nashville man in particular says he's been visiting Oscar and other death row inmates for more than a decade to pray with him. Daniel Mann is making a desperate plea to the governor to stop the execution of Oscar Smith. Although the governor has not responded to his plea, Mann says he will continue to pray.
Thursday night, I will be gathering with a bunch of other people out at Riverbend Prison, and we will be praying for the victims' families. We'll be praying for the governor. We'll be praying for the corrections officers.
We'll be praying for the governor.
Federal judge denied Smith's
I
emergency
don't mean to
motion that
laugh,
would have delayed
people,
his
but come
execution.
on.
He is set to die by...
Where have you been, Charlotte? How are you? All right, let's go to the next one, which is this the family here?
I think I just won my taxes. Oh, yeah? I just switched from TurboTax to H&R Block. It was so easy.
It's News 4 Nashville.
Good evening. An unexpected twist tonight in the execution of 72-year-old Oscar Smith. Had things gone according to plans at Riverbend Maximum Security Prison today, Smith would no longer be living.
An hour before his execution, Governor Bill Lee issued a temporary reprieve. News 4's Courtney Allen joins us here tonight. Courtney, some folks are very upset about this.
That's right. Some even gathered at a church in Nashville for a vigil for Smith. The executive director of Tennesseans for Alternatives to the Death Penalty is the one who organized that vigil. She says what happened is unacceptable. Stacey Rector is on the phone.
But tonight, you do not have to make that trip.
Rector is telling the dozens of people who were coming to the vigil she planned for 72-year-old Oscar Smith that they don't need to come anymore. Some were already at the church.
There was a problem with the preparation for the lethal injection procedure.
Smith was scheduled to be executed at 7 Thursday night for the 1989 killings of his estranged wife, Judith Lynn Robert Smith, and her 2 sons. Smith already ate his last meal. The parking lot of Riverbend Prison was prepped to hold a news conference following the execution. But just about an hour before, Governor Bill Lee said it was being delayed.
Oh, look who decides to come. Huh? Look who decides to come. Hi, Dippy. What? Oh, geez, I hope you're okay. I hope you're okay. Oh, Dippy, I'm sorry, I gotta yawn. I gotta get a hold of you later and talk to you. I got some stuff going on and a few other people. All right, people, let's continue.
Due to an oversight in preparation for lethal injection.
We're certainly relieved that this is not going to happen tonight. Also concerned that we got within an hour, basically, of an execution and discovered there was a problem.
News 4 asked the governor's office what happened, who noticed it, when, who's responsible. The governor's office said further details will be released when they're available.
How many people are on edge today?
Rector says she's thinking of Judith's family. Judith's brother and sister were among the witnesses listed for the execution, possibly already at the prison when the announcement was made.
The grief that they have suffered and continue to go through, the trauma, and the fact that this has gone on for 30 years.
The reprieve will be in effect until June 1st. Tracy.
Courtney Allen tonight, thank you.
Oh, see, I don't understand these people that sit there and say the trauma that they're, oh, Jesus. Okay, never mind. Okay, I want to ask you people who's ever here, whoever wants to answer, because I know people don't like to come into chat because a bunch of BS going on right now. Do you want to watch a portion of his appeals process? And this was 3 years ago. 3 years ago. Let's see, Judge Montgomery. Okay, there's 3 judges, a clerk, and 2 attorneys. We'll just write a quick one. Thank you, Misty. Thank you. We'll just watch a little bit.
Yay, oh yay, oh yay. This Honorable Court of Criminal Appeals
Yay,
of Tennessee
yay,
is
yay.
now in session.
Yay. Hold on a minute. Sorry, guys. I gotta turn it down. Okay. Here we go.
God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hivner. Good morning, everyone. Welcome. This is the Tennessee Court of Criminal Appeals. My name is Robert Wiedemeyer. I'm the presiding judge on this panel. My colleagues.
I need to talk to you too. Very important. I'll talk to you guys later. Hi, Tammy. What does that mean? Justice Jane, how are you, beautiful? You're driving? Okay. Good morning. Okay, let's continue.
Robert H. Montgomery Jr. from Kingsport, Tennessee, and Judge Timothy L. Easter from Williamson County, Tennessee. We're pleased to be able to handle this case via Zoom and live stream on YouTube, et cetera, et cetera. So we want to thank Nick Morgan and the folks over at the AOC, and also the people at Mr. Hivner's office for handling the technology to make this possible for us to hear the case in this fashion. That being said, we will proceed as if we were in the courtroom, and each side has 20 minutes to argue. I think both of these attorneys have been in our court numerous times, so you know how it works. Ms. Harwell, if you want some rebuttal time, let me know at the beginning, and I'll try to help you keep up with your time. Mr. Hivner, are there any preliminary matters? I think I've covered what I need to.
No other matters, Your Honor.
All right, thank you. You can call the case, please.
Oscar Smith versus State of Tennessee.
All right, Ms. Harwell, you ready?
Good morning, Your Honors. I want to ensure that you can hear me.
I can hear you.
Okay.
Yes.
Thank you. I have a fancy microphone that requires me to push on and off, and so I wanted to make sure I did that properly. Yes, may it please the court, I'm Amy Harwell of the Office of the Federal Public Defender for the Middle District of Tennessee, and I, along with Catherine Dix, represent the appellant in this matter. Judge Wiedemeyer, I would like to reserve 5 minutes for rebuttal, if I may.
All right, certainly.
This is a case about whether evidence that decimates the scientific reliability of the identification of the perpetrator at trial is favorable under the new Fingerprint Act that was just passed earlier last year. While I really want to address any concerns that the court has, in thinking about this morning, I had planned sort of 3 primary areas to cover. I would like to begin with the operation of the Fingerprint Act itself and explain to the court why we believe that the act functions to entitle us to a hearing straight away without proceeding through all of the portions of the act. Then I would like to touch briefly on why the state's statutory construction argument set out in their brief is irrelevant to the fact that we are entitled to a remand from this court. And then I would like to spend most of my time focused on the errors of the trial court in that she applied the wrong standards, both as to our entitlement to testing under 405 and to a hearing under 412. Unless the court would rather I proceed in some other fashion, that would be my plan.
That's fine. I neglected to say a moment ago that we have read the briefs, both parties' briefs, and Ms. Harwell's reply brief. So I just wanted you to know that when you proceed. So thank you.
Thank you. And I realize that I appreciate the court having an expedited schedule for this oral argument. So I realize they may be more fresh in your mind since we just filed the reply brief just last week, that there's not been much lapse of time in the court's review. So I would like to start with the operation of the Fingerprint Act and why we believe that it was appropriate to ask the court straight away for a hearing under 412. And I don't want to get too bogged down in this portion of my argument, but I do want to point out several salient points in the act itself that indicates that 412 is not limited only, as the state claimed, to cases where the petitioner has asked for testing from the post-conviction court itself. I'd like to start with 403, which expressly limits applications for testing in the post-conviction court to testing of prints that are, quote, in the possession or control of the prosecution, law enforcement, laboratory, or court. That was not the case here. The print that we tested and that we believe to be relevant in this case was provided to us in federal discovery by the Attorney General's office. It came on a disc with a sticker on it that said it was generated by the Metro Police Department. And I know the court has, as you said, read the briefs, so is aware of the testimony about how that print, which print it was. But it was not a print that was only in the custody or control of prosecution or law enforcement. So we believe that under 403, we weren't required to ask for testing from the post-conviction court. 406, the provision right after the testing provisions, 404 and 405, makes clear that if 404 and 405 apply, 406 then is about who pays. It uses a limiting clause. If an order is issued pursuant to 404 or 405, then this is who pays. 408 comes most closely to discussing our situation and sets out what the court and the parties are to do if there has been testing by an independent or outside examiner, and requires disclosure of those examiners' results if there has been an outside examination. And we followed 408 in this circumstance. And then 412 discusses which lab is to do the analysis, again with a clarifying phrase. If the court orders analysis, then 412 applies as to which lab should do the analysis. All of this matters because none of these sort of qualifying provisions appear in 412. The provision in the statute mandating a hearing does not have if the post-conviction court orders testing or if testing is given under 404 or 405. Rather, it just simply says that testing, that a hearing shall be granted if the results of the testing are favorable to the petitioner. And I would submit that under the canons of statutory construction, given that the legislature clearly knew how to limit several of those provisions to circumstances where if the post-conviction court has ordered testing, the fact that 412 is not so limited means that the state's interpretation of the statute fails. And then I want to, as I said, touch very briefly on why the state's interpretation doesn't matter at all. And that is because whether under the state's interpretation of a petitioner should have to ask for testing from the post-conviction court before they get a hearing, or under our interpretation of the canons of statutory construction, as I've just outlined, either way, we asked for testing under this statute. It was an alternative form of relief requested from the post-conviction court, asking for testing on the basis of the evidence we already had. Turning to the things that the post-conviction court did wrong, the post-conviction court made two errors in denying testing of our sample. First of all, the post-conviction court did not assume that the results of the testing would be favorable, as was required by Powers versus State. And that is, I'm sure the court knows, the Tennessee Supreme Court case from 2011, where the Tennessee Supreme Court said, for purposes of determining whether tested is warranted. Now, granted, at that time, the court was talking about the DNA Act, but we know that the legislature intended the Fingerprint Act to closely track the DNA Act, so Powers is certainly instructive. For the purposes of determining whether testing is warranted, we must presume the testing results would prove favorable or exculpatory to the petitioner. And the reason I say favorable or exculpatory is because it depends on whether you're asking for testing under 404 or under 405. This court, that is the Court of Criminal Appeals, has followed that language in Powers multiple times, as applies to 405 cases or 305 cases under the DNA Act. They followed it in Johnson, Hart, and Rucker. That is to say, when a court is going to decide whether to allow testing or not, the question isn't whether the analysis will be favorable. The question is, if the analysis is favorable, would that have made a difference? And I submit that the court below erred on that second prong as well. And I think she erred on that second prong in part because she did not assume the results would be favorable. I think an analogy would be, by way of just being very clear, why the result would be favorable to Mr. Smith, or would change the outcome if the testing were to show that the print matched a serial killer who's incarcerated in Texas. That would certainly change the calculus and undermine the confidence in the jury's verdict. And if the trial court or the post-conviction court below had presumed that the result would be that kind of favorable result, it would have been obvious to that court that the result would be different. However, even under our proof, even if the post-conviction court weren't to follow the Supreme Court's instruction in Powers, our proof, and just consider whether the result would be different with our proof, still under Powers, as discussed in our brief at page 29, we were entitled to testing. As Powers says, there's nothing in the act limiting DNA testing to only those cases where there's a tenuous evidence of guilt. Instead, what the post-conviction court did here was review all the proof that had been discussed in terms of a sufficiency of the evidence standard and said, well, if there was new proof that was said that the fingerprint evidence was inconclusive, that wouldn't have rebutted all of these things that support the verdict. Powers says that's not the standard. Judge Easter, you joined an opinion in State versus Thomas back in 2016, where the panel you were on remanded for testing in a situation very similar to this situation we are in, where a favorable result would have impeached the key proof identifying the defendant as perpetrator. And we believe that this situation is very similar to that result in State versus Thomas. Also, Judge Wiedemeyer, I found really instructive language you wrote in Haddock versus State, which the Tennessee Supreme Court has cited multiple times with approval, particularly in Powers, that exculpatory results doesn't require that the results contemplated or the results of the testing must indicate with certainty that the petitioner is innocent, but rather could be something that impeaches the main evidence against the defendant. The other big mistake the trial court made below was in failing to properly consider residual doubt. And she did that, I think, in part, the only discussion she has in her opinion of residual doubt is in her denial of testing. But I think that while she doesn't even address it in her discussion of denying us a hearing, she did in the denial of testing say that she was denying it in part because under the pre-89 law, the statutory aggravators did not have to outweigh the mitigators beyond a reasonable doubt. The problem with that analysis that she clearly used in denying us both testing and a hearing is that she has the law wrong. Under the Sentencing Reform Act of 1989, anyone sentenced after November 1st of 89 gets benefit of the new act. That is found at TCA 4030-117. I know this court knows this part well. And there's also then the savings statute from 3911-112. Unfortunately, the post-conviction court considered the wrong law, but I'm here to tell you that Judge Wyatt, back as the trial judge, got the law right. If the court consults the record of the original trial at page 3275, Judge Wyatt instructed the jury that the aggravating circumstances had to outweigh the mitigators beyond a reasonable doubt. And that is the calculus this court must use to determine whether our proof that decimates the scientific reliability of the state's identification of our client as the perpetrator is favorable or not. There's the other mistake the trial court
Oh my
made
God, lady.
in that analysis.
Oh my God. Oh my God. Her 5 minutes is up. I don't know what you people think about this, but her 5 minutes is up. Hold on a minute.
If the court doesn't have questions for me now, I will reserve the remainder for rebuttal.
All right. Thank you. General Simpson, you ready?
Yes, Your Honor. Good morning. May it please the court. Samantha Simpson on behalf of the state. Your Honors, this court should affirm the post-conviction court's determinations that the petitioner failed to establish his entitlement to fingerprint analysis or hearing. He presented the court with his own handpicked analyst, but even that handpicked expert's ambiguous analysis failed to establish a reasonable probability that he would have received a more favorable verdict or sentence. And because that inconclusive analysis was not favorable, the post-conviction court properly determined that a hearing was not warranted. Now, the petitioner's counsel discussed the statutory framework of the Post-Conviction Fingerprint Analysis Act, but the act specifically contemplates a hearing to consider the court-ordered analysis. Even the provision allowing a petitioner to file that petition specifically states that a petitioner may request fingerprint analysis. Now, while the act does contemplate situations like the one we have here, where there is pre-existing analysis, and that any party with that analysis is supposed to disclose that. When we look at the provisions that provide for the testing in conjunction with 410, which explicitly states that the analysis must be done by a court-ordered laboratory, and the court should first order the original laboratory if that's available, and if that laboratory is not available, then the court can order testing from a laboratory that it deems appropriate. After that court-ordered analysis is obtained, then the court looks at the results of the analysis, determines whether it's favorable, and whether the petitioner proceeds to the next step in this act, a hearing.
Okay.
So
Okay.
the petition.
Do you guys understand what's going on here? This is what's going on here. So what they're saying here, they're talking about fingerprint evidence. Okay. And I'm sure they're not going to go into details, but I will. I know nothing about this, people. I just bring it up. That's all. Now, we are going to go to this appeals docket, okay? Because, who is this? Is this Tennessee or Texas? Oh, it's for Oscar. Okay. All right, the background. Okay, we don't care about that. What we care about this. Okay, this happened on October 1st, 1989. Can you guys see this all right? I can make it bigger. There we go. All right. 1989, the police received a 911 call from Judy Smith's home. On the tape of that call, later technically enhanced, a victim shouts, among other things, "Frank, no, God help me," before the call abruptly ends. Now, shoot, let me find the picture, you guys. Oh, gosh, I hope I can find it. The crime scene photos. It shows where he ripped the phone out of the wall. The whole phone jack, you guys. Hold on a minute. Shoot. Let me find it. Shoot, shoot, shoot. Well, maybe I'll find it later, you guys. We don't have time for that right now. But there are crime scene photos of the damage that he did. He tore up that place. All right. Operators arrived 5 minutes later, heard nothing, received no answer at the front door, considered it a false call. The following afternoon, oh no, the bodies of Judy, Frank, and his estranged wife and his two stepsons, Jason and Chad, were found unalived. Smith's twin boys were somewhere else the night of. Okay, so she had 4 kids. Got it. The night of the murders. According to the medical examiners, 3 victims died at least 12 hours before they were found. Okay, they used an awl, A-W-L, a knife, and a .22. Police found a bloody handprint on the sheet next to Judy. Okay, Sergeant John Hunter, who examined the print, testified that it matched Smith's left hand, which was missing the 2 middle fingers. Okay, this is what they were talking about, I think. They're talking about the fingerprints in that appeal that we just watched. Smith claimed that he spent October 1st with Judy till 9:30. When he took the twins back to his home 30 miles from Judy's house, approximately 11 p.m., a neighbor saw Smith's vehicle parked outside Judy's house. His work required him to conduct business in Kentucky the next day, and Smith convinced his lawyer to let him depart Sunday night rather than Monday morning. After leaving Judy's, he took a 300-mile road trip, and visited a customer at 8 a.m. before returning to his home that afternoon. When police officers picked him up the same day, Smith never asked why he was being questioned. Even before officers told him of the death of Smith, spoke of his wife in the past tense. He showed no emotion, and he had abrasions on his hand, elbow, back, and shoulder blade. So Smith here, he always showed acts of violence to his family, to the victims. He fought with Jason, bit him, and held a pew-pew to his head. He tied up Judy and arred her. Oh my God. Ran a knife across her. Repeatedly called her work with threats. He also threatened Chad and Jason because Judy treated them better than his children. He took out a life insurance policy on Judy and her stepsons. Okay, they said here, what's this here? A glove found at the scene. Wow. Hold on. So he presented an alibi defense, and a jury of his peers convicted him. Okay? And then they talk about all the appeals that they had done. And what date was this one? 2010. Wow. All right, we are going to watch this real quick. Right? And I did see some of the crime scene pics. I mean, he read that, on the wall back then, it's the telephone, the phone jack and everything was all ripped out. Nobody could call for help. It's terrible.
Family justice for what Smith did.
It was one of the worst, I think, crime scenes that I had seen.
32 years ago,
Watches.
then Nashville Police Captain Mickey Miller walked into a home and saw a horrific scene.
We did. We already watched this. Never mind. Hey, Misty, did you decide what movie to watch for tonight? I'm sorry. Oh, gosh. Because I haven't yet, but I really haven't had, honestly, time to look. But remember what I do want to do at a time. Remember we talked about it? There's a 3-part series of the Mafia that I want to watch. Yeah, do that, and then I'll come back live again later, and then we'll decide. I will play the trailers into what I find. And I do got to talk to you today also, privately, not on live. I've got a lot going on here. I'll just leave it at that because it's nothing that the internet needs to know. Let's see, what else? So, yeah, these are April. The other April ones I just did, the other 3 men in April, I just did that last week. And then these are the other 2. And then the next bunch is going to be for May. However, I'm going to continue doing the women. We are now on, I'm starting on, is it California? Yeah. So all I got is California and Texas left. And there's like 25 of them, the female ones that are on death row. Love you, Charlotte. Okay, you enjoy your garden. Yeah, I've been gone for 4 days. Last time I was on here was Thursday, and then I came back on last night, as a matter of fact. Because it gets so dark doing this and so toxic. There's cases that are so toxic, you got to. All right, everybody, I love you all. Everybody in the bushes, thank you for being here. And yes, I will see everybody later. Misty, I'll talk to you later. Love you all. What? We missed you, or at least I have, but understand you need a break. Yeah, because this stuff gets dark, and I got to get back into doing hardcore my missing people that I used to do. Remember, I used to do like 3 to 5 people a day. I got to get back to that. But I do want to say to people, and I do agree, not everybody's guilty on death row. There's a man in Missouri, right, Misty? I don't know how they convicted him. There was not his DNA there. There wasn't his blood. He wasn't even in the state. He wasn't even in the state. And they convicted this man. However, he spent 16 years and he's out. But see, that case don't make no sense. How could a jury convict him? Can you say corruption? What, you can't do it when you're out of state, people. Love you too, sis. Okay, this is all I gotta say. And I will be back later. I'll try to figure something out. Okay? Okay. Love you all.